gun violence, gang violence.
The indictment of 63 young gang members in New York City made big news in April 2013.
We are announcing 3 new indictments, which bring serious criminal charges against 63 individual gang members of 3 of Manhattan's most violent street gangs.
But in a sign of the times, the spotlight was also on the investigative methods used by police in making the cases.
And through monitoring social media,
hundreds of postings from Facebook, Twitter, and other social media sites were included in the DA's indictment. The authors apparently didn't realize how those posts could compromise their future.
These are low-income housing projects with kids whose basically life expectancy to them is tomorrow.
Hershel Katz is a veteran New York City defense attorney who is representing one of those charged in the indictments. For him, there's an ominous aspect to using social media to catch criminals.
It's a very sexy topic and it sounds very interesting. You know, they're getting all these bad guys off the street, they're getting guns and all this other stuff, but it goes beyond that.
So what does a case involving 60 gang members in New York have to do with the general public? Everything, says Katz, because it involves privacy in the digital age.
The issue becomes, at least from a legal point of view, is do you give up your right of privacy or the expectation of privacy when you use a social media to communicate?
The Electronic Communications Act of 1986 and Title II of that law, known as the Stored Communications Act, address privacy issues governing email. But social media as it exists today wasn't around then, and Katz says that has created some gray areas in the law that tilt the scales of justice toward prosecutors.
Since it's now out there on the internet or on the cloud or however it is, that it now becomes fair game for them to have access to it, where in the old days you had to get a search warrant.
And Facebook's policy is to work with law enforcement, stating that, quote, we may disclose information pursuant to subpoenas, court orders, or other requests if we have a good faith belief that the response is required by law.
We're arguing as defense lawyers that our clients have, there's common law rights to privacy, there's statutory rights to privacy, there's legislative rights, and there's constitutional rights to both privacy and also freedom from unwarranted or illegal search and seizures.
It's an argument, according to Katz, that will probably wind up in front of the Supreme Court. In New York City, this is Ed Alpern reporting for the Lawyers.com channel.